Good morning, Advocate. I'm sorry, how do you pronounce your name?
It's Holland Muter.
Holland Utah.
Thank you, Deputy Chief Justice.
Thank you. Good morning, sir. How are you today?
Nervous, but okay.
But you're an old hand at this. How many times are you coming before us now?
No, but it doesn't take the nerves away.
Yeah, well, I hope this will make your life a little bit easier. This body has tested your suitability as a judge, I don't know how many times now. So I think we have enough information on record to establish that you are a sound lawyer and a fairly decent human being, if I may say so. So I'm not going to ask you any questions. We know exactly who you are. The record speaks for itself. I'm just going to ask if, well, your last interview was it was as recent as October 2022.
That's correct.
It was barely 6 months ago. So all I'm going to ask is whether there is anything earth-shattering that has happened, to enhance your CV that you'd want to bring to our attention. And if there isn't, I will hand over directly to JP Mlambo.
Thank you, Deputy Chief Justice. The only thing which changed since I filed my application is that in the first term of this year, at a very short notice, the Deputy Judge President phoned me and asked me for assistance. And then in the 10 weeks, on loose standing weeks, I assisted the Pretoria High Court for 5 weeks, ending in the last week of term in the urgent court. So the statistics have changed because there are 5 further weeks, and unfortunately, because it was in the last 2 weeks of term, end of the term and so on, I've got 2 outstanding reserve judgments which I picked up then 2 to 3 weeks ago.
Those are very fresh. Is that all?
That is all. That is all. I have obtained more grey hair, but that's natural.
So have we all.
Yes.
You're in good company. Thank you very much, Counsel. All right, JP Mlambo, I'm handing the candidate over to you, sir.
Thank you very much, DCJ. Good morning, Advocate Holland Muter.
Good morning, JP.
I think the DCJ is correct. You've been here. This is your 4th time.
Fourth time, yes.
Yeah. And in this room, only the Deputy Minister and the Speaker have not featured did not feature in your last interview. Now, so the DCJ is correct.
Yes.
You've been here, we know you. But this is what I want to ask you. You've acted for a total of 100 weeks now.
That's correct.
And that's because of the example you've just given, that at any time when we run into a problem, a judge falls ill, we need assistance, we know we can call you and you can come.
When available, yes. Because it's a duty which I have to my country and to your division.
Yeah. And I want to thank you for that.
It's my pleasure.
My role as JP of the division is to ensure that people who are hardworking, technically competent, and conceptually up to standard are appointed in the division. Now, I've looked at your acting stints. You've acted for a total of 14 weeks, if I'm not mistaken, in the opposed motion court.
That's correct.
That's a court where it's a warehouse for reserve judgments.
For sure.
And you've also acted in the special motion court. That is the 3rd court, right?
Yes.
As well as in the urgent court, quite a number of times.
Yes.
In fact, the urgent court also warehouses a number of reserve judgments if you don't hit the ground running and you're not confident to do extempore judgments.
Yes.
Now, looking at the terrain, the comments that have come, have you been criticized in any way about your judgments? How you've reasoned them, whether they are shoddy pieces of work like that. They are replete with grammatical errors, typos, linguistic issues, weak reasoning?
Well, JP, the comments which I received from the various bodies, all of them stated that I'm a fit and proper person, that my knowledge of the law is good, my writing skills are good, and so on. So, no, in the recommendations or the documents which was forwarded to me, there are no serious criticism on the quality of my work.
Yes.
The Commission, everybody has it with them. No. I may also say is that from time to time a year from Council that they are very satisfied with your judgments. I even had instances because many of the judgments which are not reported, but they hear about it and they phone your registrar or come to you for a copy of that to use in their arguments and so on. So it's not that I want to be profess that I'm very good, but no, there's no serious criticism which I'm aware of.
Yeah. Your list of judgments, I think you list 69 judgments, is that correct?
That's correct.
Okay, but for having acted for so long, that's a bit of a low number, if one may say so.
To a certain extent, yes. The more experience you gain, especially in the courts, the default judgment court, etc., you become confident to give extempore judgments.
Yes.
And with the rider that if the parties would like further reasons, they're welcome to request that. Especially in the urgent court, because the whole purpose of the urgent court is the people want urgent relief. Then it happens from time to time, especially towards the latter time while I was acting the latter years, is that you give a very short extempore judgment and then you elaborate on that, and that is where some of the reserved judgments come from.
Okay. Thank you. My last question, DCJ, is having looked at the last interview where you face questions from this body, and you may go to other interviews, what were the points where you were criticized, and if there are any, can you tell this commission if you have improved on those criticism points?
The one criticism, JP, is that, I can't remember who it was, the commissioner said that he sees no growth because we're talking about weak and strong points. And under the strong points, I mentioned that I'm very dedicated. And on the question, the answer, because it was on one of your questions, referring to the opposed motion court and the urgent court about the volume of work. My answer was that it from time to time means you work after hours, after midnight. And then the question was posed to me, but you work hard doesn't mean you work smart. I have, having read the typed version, did some, in retrospect, questioned myself whether hard work after hours so late is necessary and how can I improve on that. And I've come to the conclusion that the volume of work does not decrease. And I will, in future, whether acting or appointed, when you are faced with matters, especially the opposed motion court, the week before that, because you don't have, like in the unopposed court, a reading week in advance. You get it the Monday or the Tuesday for the Monday coming, your opposed motions, but for instance, you may still be in the unopposed court or in the trial court. You have to prepare after hours. There's no question about that. And my motto is, and that is many of the reports I received back from counsel, is that my preparedness when going to court, especially in the opposed court, is that I know the papers well. And that takes me in instances after hours, after midnight, and even on weekends. But yes, I have had a look at that to see whether I can improve on my system. But with regard to that, to a large extent, it's dependent on the volume of work which you have to go through. Because in the opposed court, having 12 to 16 opposed motions for the week, it boils down to more or less 1,500 to 2,000 pages which you have to prepare. And that's a lot of reading to do while you're still in the week before that, busy with other work. So you have to do that. A question was asked about my weaknesses, and I said it may be seen as a weakness, is that I have a very soft spot for children and females or abused people. A weakness in abbreviations, because I know that those people are the people who are most vulnerable, and they are the people who need protection. So if I can state it, overprotective towards them, I don't feel that I'm failing my duty towards those persons, because those are the people who normally don't have the opportunity to speak for themselves, and they need to be protected. That was that. Then there was the aspect on which I was criticized as being a senior counsel, and the comparison was drawn between Johannesburg and Pretoria, that I had less juniors which I led should have been in Johannesburg. But that is also dependent on where you are, the kind of work you do. And you have to remember, the fact that I'm in practice for 23 years does not mean from year one you have a junior with you. Your first 12, 13 years as a junior counsel, you build a practice, and then after that you start, before you obtain silk, is take in juniors and advise them. I have explained that I've a category where I take juniors in on full brief. I take in them on my account with the consent of my attorney, but I pay them out of my fee. And then there are those, because for a long time I was the convener of the pro bono committee at the Pretoria Society of Advocates. And by doing so, to give juniors and pupils who have the right of appearance the opportunity to come into court, I've roped them in. I take them, and I take them to court, and I give them the opportunity to first experience the court. And at a later stage, you take those people in, those young counsel, when there's a pro bono brief or so, and you ask them to prepare it, but you go there to keep their hand. In my view, that is to give them the opportunity to be exposed, and that is to help them to become better counsel.
Yeah. In terms of your work, your performance as an acting judge, is there any criticism? Because if there's none, then I don't think you need to be...
No. In my view, no. I'm not aware of criticism against the quality and the work which I've delivered.
And your judgments?
And my judgments, no.
If none, that's fine. If none, thank you.
Thank you.
Thank you, DCJ.
Thanks, JP. Do you have questions, MEC?
Yes, just one. Good morning. I see I'm right here.
Oh, yeah, good morning. I saw the hand there.
Okay.
Yes, MEC.
Yeah, I just have got one question to you. And I just wish to get your insights on perhaps a comment, if it were to be made, that your appointment may not enhance transformation. In other words, it will not be considered a transformative appointment. Well, what will be your take on that, on gender, on Africans, black people, and youth, given your age?
MEC, the Constitution in Section 172 amounts to that. To be appointed as a judge in the High Court, you have to be a fit and proper person. I know and then it's further, there are the restrictions of other legislation. I accept and I agree that there must be transformation of the judiciary. To a large extent, that has taken place. According to the statistics in the report from the GCB, at present there are 75 judges in the Gauteng division, of whom only 15 are white males, which amounts to about 18.5%. So I hear what you say about that. Would my appointment send out a message to the public in general? If it's only on the question of the color of my skin, then there may be questions. But that's only one factor to be considered. If you take into consideration that there are no serious comments from all the institutions who had the opportunity to give their commentary, it would be sending out the correct message to the community that, and I'm not boasting myself, but my appointment will be in the interest of the bench of Gauteng, because there are no serious criticisms at all of the quality of my work. So the public outside can rest assured that a fit and proper person has been appointed.
Commissioner Rakis?
Thank you, TCJ. Do you agree that language can be an impediment on the project of transformation, for the reason that the language of colonizers becomes the most preferred language than the other languages? In this instance, this relates particularly to judgment writing. For instance, I read the comment on yourself, your judgments are well-reasoned, well-written, because you write in your own language.
Yes.
But generally, the GCP, when analyzing other candidates, would be very critical of their language. So I want to know from you, do you agree with me that the issue of language is central to transformation?
Yes, of course. Language, not only language, but culture is of importance in transformation. And that is why under the previous Chief Justice there was a strive that the official language of judicial procedures are in English. And English is not my first language. So we are all, to a certain extent, standing a bit back from your language. I know from my involvement when I was still on a governing body of schools for many years when my children were there. We had satellite schools in the rural communities which we assisted. Education in mother tongue language up until a certain age is non-negotiable. It should be done. But we sit in a society where we have 11 official languages, and we have to marry that. And by doing that, we all have to, but for the people who are English-speaking from their first language, we all have to make sacrifices. But there must be, and I know, and thank you for the comments on the language in my judgments, but at some stage somebody, and that may be avenue to have a look at, is to explain it from time to time from the judiciary in workshops or so with people in rural areas what a specific judgment may mean in simple language of theirs. I am unfortunately not proficient in any of the indigenous languages, which is a pity, because I wasn't given the opportunity when I was at school. There were not indigenous languages offered to us.
With your leave, Chief Justice, just that's the last portion on this question. When you first wrote a judgment, that is, as an acting judge, what challenges that you experience, and how would you relate those challenges that you experience to other acting judges, in particular the black judges, acting judges? Thank you.
Commissioner, the difficulty I had when I first started acting in 2015, I had a very prominent senior judge sitting next to me, and my JP will remember Judge Fabricius. Not only was he good, very proficient in English and Afrikaans, but also in German. And because of the difficulty of writing judgments in English, being Afrikaans speaking, I approached Judge Fabricius many times to assist me with the language. And that is, I think, which should be done, that from judges and acting judges, there must be some sort of fusion that acting judges must have. They must feel free to approach a judge or a senior person to assist them in the beginning, not only in the beginning, but also as it goes on. From time to time, that a senior judge just have a look at it and assist you to better your quality.
Thank you, TCJ.
Thank you, Commissioner Kies. Prof?
Thank you very much, Deputy Chief Justice. Good morning, Advocate.
Good morning, Commissioner.
I was going to ask you about something else, but your answers to both the Judge President and Commissioner Nyokesi drew me to what I'm going to ask you on. You were asked a question in relation to the quality of judges and the judgments and the criticisms. And you repeatedly said that there are no criticism that you are aware of, and correctly so, because we have not been furnished with any. And Commissioner Nyokesi also asked about the quality, and you also said you yourself are not aware of the challenges in your judgments. And then that drew me to the judgments of yours that I know I've read before. The first one is the one where you dealt with Matrimonial Property Act, and you dealt with issues of forfeiture and all those kind of things. But for the purpose of time, I want to go to another one that you wrote. This one you wrote, and that judgment was riddled with difficulties, right? Which I'm not really sure why the independent bodies were not able to pick up on those. But the one that I want to debate with you on is the one that you wrote in insolvency law. The body corporate of Heiselhurst versus Ramachia. It was delivered on the 27th of October 2017. I'm not sure if you remember that judgment. It dealt with, from what I can gather when I read the fact, it was compulsory sequestration. But when I read the judgment, it seems like you are confusing compulsory sequestration with voluntary surrender. And I'm going to point out something and I want your comment on it. The difficulty that I have with this judgment is, and I'm not sure, it's not part of the PEG, unfortunately. I don't think it's part of the PEG.
Of the bundle?
Yes. In paragraph 9 of that judgment, but do you remember that judgment?
It's
because I want to be fair on you, but the thing is, I'm asking this based on the criticism that you raised.
If it's a 27 judgment, it's
2017.
Yeah, 2017. It's some time ago. I've had a couple of insolvency matters which I heard. So no, I don't recall.
But can I just point out?
Yes, you can.
The issues with this judgment in response to your response in relation to the quality of your judgment?
Yes, please.
In paragraph 9 of that, in paragraph 9 of this judgment, what you first do, you speak about the acts of insolvency, and you list about 5 of them. And when you start speaking about acts of insolvency, you give an impression that you are dealing with compulsory sequestration. In other words, what you are dealing with here is compulsory sequestration. And once you have outlined these, in the following paragraphs, you don't even deal with any of these acts of insolvency and what or which one of them is actually applicable in this case. And there is no reasoning in relation to the requirements of compulsory sequestration and as to why the person who is being sequestrated in this particular matter meets those requirements. And that is the first flaw that I found in this judgment. But apart from that, you confuse issues. In paragraph 21 of that judgment, you say something that is quite surprising. You speak about somebody making a notice to surrender their estate. And if you start saying somebody surrendering their estate, you moved away completely from compulsory sequestration. Yeah. You are now dealing with voluntary surrender. And that is the second issue that I have with this judgment. That shows, one, confusion in relation to the area of law. But secondly, lack of attention in relation to the research that is needed to actually get into the reasoning and the order that you're going to give. But the third fundamental challenge with this judgment is the language that is used. In paragraph, you can just bear with me just for a second. In paragraph, I think 20 of the judgment, the language, the sentence construction that is used there, and when you read the entire judgment, and I mean it's unfair because you don't have that judgment so you can see. But I just want to say that this judgment and the judgment that I referred to, it has similar sort of things that come out of them, where you rely on the law, not the law in terms of cases, but the law in terms of the statute itself, but your interpretation of the statute and your reasoning in relation to the statute leaves much to be desired. So I'm not sure whether it's accurate to say that the quality of your work generally, it is satisfactory. I think there are points of weaknesses, and it's quite disappointing that some of the bodies have not highlighted it, and which raises a concern that perhaps maybe criticism seems to be restricted to certain people and not other people, and that for me is a concern. I'm not sure. What is your response to that?
Firstly, Commissioner...
No, DCJ.
Commissioner Madam?
I think in all fairness, that question is not in keeping with what we have adopted. Because it's not only the law bodies that have got a right to raise issues with the candidate before he sits here. We all do. If we look at the law bodies report and the issues we have, which the law bodies have not raised, we all have a right to raise those issues and send them to the candidate. And that hasn't been done. Yeah. And it's not me, it is through the admission of the commissioner that hasn't been done. And it's unfair to the candidate and to all of us, because even in the deliberations, that point cannot be referred to, since it has not been canvassed.
Thank you, Commissioner Malema.
Before that, I take a point, but the thing is I'm raising an issue based on a judgment which is a public document, which of course all of us will have access to, and we did that even yesterday, where somebody said the Supreme Court of Appeal confirmed me, and we all went to try to see whether indeed the Supreme Court of Appeal has actually done that. So the question that I'm raising is in relation to the judgment that the candidate actually authored. So it's not about the bodies or any other person criticizing. So it's my criticism to the candidate. So it's not really about anyone else. It's my criticism as the commissioner to the candidate.
Thank you. I hear you, Prof. But look, the judgment you say was written in 2017, and he has written dozens of other judgments since. So it may actually, I'm trying to put myself in his position, and I'm thinking out of all the judgments I've written, if I were asked on a judgment I'd written some, 5-6 years ago,
I accept that.
It might be difficult, but the Advocate Holland Muta looks ready to answer. I don't know what he was going to say. Let's hear from him. If you feel that the question is unfair, you will say.
Before that, DCJ, let me just say this. I understand that. I said the question was based on the assumption, or the saying that there's never been a critique in my judgment. Then he went further and said, I am not aware of any challenges in my judgment. So I was asking on the basis of the second leg, I am not aware. So I was raising that on that aspect.
And I just ask for clarity if this judgment was appealed against?
No, it wasn't.
It wasn't. All right.
If I may, Deputy Chief Justice, respond to that, and I would like to thank Commissioner Malema for that. Yeah, it is an ambush question, and I cannot respond to that because I don't have it before me. I'd never said that I never made a mistake in any judgments. I said, in overall, I am not aware of criticism. And if this is a valid criticism, I would have expected, and in all fairness to all candidates, not only for me, but all the candidates who come here, is that you have in advance that criticism circulated to you so that you can be prepared. That is as far as I would go. I cannot comment on that. But a last thing is, if it was 2017, yes, I would agree in general that the quality of my writing of 2015, 2016, 17 is not as good as it is today because there is an improvement.
Thank you, Advocate. Well, Prof, you have your answer, and you've
No, it's
exhausted
fine.
your quota of one question a long time
No,
ago.
I'm done.
Yes, I also have a question.
Thank you. Good morning, Mr. Holland Mutter.
Good morning, Commissioner.
I can obviate the whole debate about referring you to a judgment that you're not aware of by referring you to a judgment in your pack. Now, I assume that you put those judgments in as a sample of your writing, and those are the judgments you want us to consider your application based on. Am I correct?
You're correct.
Right. Can I ask you to look at the solidarity judgment? It begins properly at page 219 of the pack. Now, the first point I want to make, Mr. Holland Mutter, and I do this in the context that we've been quite stern with all of the candidates that have appeared in the course of this week in terms of structuring of judgments, as well as where judgments are riddled with errors, etc. Just want to firstly put to you the broad proposition that this judgment, and I accept that it's a judgment handed down in urgent court, but that this judgment is riddled with typographical errors and spelling errors. Do you accept that?
I accept it if you say so.
The second thing I want to put to you about this judgment, and I've been through the judgment quite carefully, this is a judgment handed down in the context of an application for an interim interdict, pending the review of, in this case, it's the review of the Tourism Equity Fund, the creation of the Tourism Equity Fund. You recall the matter?
I recall that matter.
Yeah. So if one goes through the judgment, and I've got limited time, so I can't go through it quite as carefully as I normally would have, there's a few things I want to just point out to you that raised a concern when I went through it. And the first one appears at 221 of your judgment. If you look at the paragraph 8, you say it was a concern on behalf of the respondents that the relief sought by the applicants amounted to the court usurping executive powers because the action attacked amounted to the exercising of executive powers not subject to judicial review.
Yes.
So that was the first red flag for me, that what you've reflected there is your understanding that the exercise of executive powers is not subject to judicial review.
It should have gone further and said that under normal circumstances, but in exceptional circumstances, I agree, it is subject.
No, but I'm sorry, even that is not a correct reflection of the law.
Yes.
And I really don't want to debate the law with you. All I'm raising with you is what this judgment reflects.
Yes.
It's a very tenuous grasp and understanding of the basic law of review. That's the first thing. The second thing is if you go through the judgment and you say in page 223 of the judgment that what you want to do is you use the term peek. You want to peek into the merits of the main application for review in order to decide whether or not to grant the interim interdict. Right? When you do that and you see it gets dealt with from page 225 of your judgment, when you're dealing with the review, what you do is that you start making reference to the outer test. Now, you'll know that the outer test applies in the context of the interdict, the interim interdict, not in the context of the review. So what you do there is you're conflating two issues, which again is another red flag in terms of your understanding of where the outer test comes in and how it should be applied. Then the third and final thing that I need to raise with you is if you carry on through the entire judgment, and now we're looking at it from the perspective of structure. Again, what you're dealing with here is an application for an interim interdict. You don't see anywhere in the judgment that you deal with each of the requisites for an interim interdict. It's simply not there, despite your finding ultimately that the application should be successful. Perhaps you'd want to just respond to that.
Well, I hear what you say, that I should have, and it's preferred, if you do it in a proper way, that you take each heading which is applicable on a clear right, no other remedy available, convenience, etc. Yes, I would accept that. I should have done it more that way.
Thank you. Thank you, DCJ.
Could I ask for permission to just follow up, because my question is also on the same judgment? Thank you, Deputy Chief Justice. I counted at least 5 typographical errors in the judgment, but that's not my question, but I really want to caution this general acceptance that there's nothing wrong with your judgments. But the other thing I want to ask you is your understanding of Section 9 of the Constitution, because in this judgment you do reference the Minister of Finance versus Van Heerden judgment. So firstly, I want to ask you what the Huxon test entails, and secondly, how does it differ from the Van Heerden test? Because those are the prima facie questions you should have answered in this judgment that Commissioner Pillay shows that you didn't answer.
Yeah. No, I agree. I should have done that. The only defense that I have is that this was because of the urgency of the matter, I had to do it rather speedy.
No, but what is the Huxon test? How does it differ from the Van Heerden test?
I'm not going to waste your time. I'm not prepared on that. So no, I cannot answer you out of the first on that.
Thank you, DCJ.
Council. AP Beto.
Thank you, DCJ. Good day, Mr. Holland Matter. Lest I be accused of inconsistency, I have 2 simple questions that I need to pose to you. The first one, you are presiding in a civil trial concerning a delictual claim for patrimonial loss, and the only element that is put in issue is negligence. As a presiding judge, what test then would you need to apply for purposes of liability to determine whether negligence has been established?
Well,
In essence, the court asked itself 3 questions. If you could share those questions briefly with the Commission in the interest of saving time.
starting with to define negligence, you go to the classic of Kruger versus Coetzee, the 1966 then appellate division. Was it foreseeable by the reasonable person that his conduct will cause patrimonial loss? If so, did he take, or should the reasonable man have taken action to avoid that? And then the third question is, did the defendant take action to avoid that or not? And if the question is answered that he did not take evasive actions, then the inference would be that he was negligent.
Thank you. And my second and last question. You are sitting as a member of an appellate court against, in an appeal against sentence. Forget about let me say, in circumstances where the minimum sentence legislation finds no application. Under what circumstances would interference with the sentence imposed by the trial court be warranted?
Well, a court of second instance would normally only interfere if the court of first instance sentence was shockingly inappropriate. If not, the fact that the Court of Appeal may have a different opinion, but it is not to a varying to a large extent from what was imposed by the Court or quo, normally would not interfere.
I'll leave with that, although it's not the complete answer I expected from you. Thank you. Thank you, DCJ.
Thank you, AP. Commissioner Singh?
Thank you very much, DCJ. I'm on the platform. Good day to you, Advocate.
Good day.
Just one question. You were born in 1961, so that makes you 62 this year.
No.
Now, if we look at 176.2 of the Constitution and we look at the subsections 3.2 and 4.4, it speaks to the term of service of a judge. Now, what is your interpretation of how many more years of active service you offer if you are appointed.
Can I just correct you? I was born in 1956, not 61, as you said.
Okay, I saw 61. So if you can just calculate that and tell us the
I'm
question will be how many-
66. I'm 66 at the moment. I have at least 8.5 years active service which I can render. If you look at Section 4, Sub 4 of the Remuneration of Judges Act, it allows a person to go past the age of 70 up until 75, and if you do not complete a full term, then there are certain formulae which comes into operation in the calculation of your salary, which should not be less than 40%, and also the gratuity. There is a certain formula which, so it's not unfair towards a person who serves longer. It's just to bring a proportion there. But
Thank you very much.
I have 8 years at least.
Thank you very much. Thank you, DCJ.
Thank you.
DCJ, just a follow-up on this, on the same, just quick
All
one.
right, Commissioner Dodo.
Last time when you were here, I'm here. Advocate,
so-
I'm
so-
here,
sorry.
yes. Last time when you were here, I expressed a view, and the view was that I'm impressed about your determination. You don't give up.
No, why should I? Because I want to serve.
You don't give up at all. And just in my heart, when you entered, I said, in a colloquial way, this man is here again. But it's okay. Now I can see that intellectually and mentally you are okay. I just want to find out, physically, are you okay?
Yes, I am.
No major operations?
No.
No diabetes?
No.
High blood sugar levels?
No.
Okay. All right, thank you.
I also don't have any heart problems, but only for my wife, but I don't need heart medicine. No, I'm in good health. I go once a year to the physician just for a checkup.
I'm not sure I'm comfortable with those questions, Commissioner Dodo. They cut too close to the bone. Commissioner Malem?
No, thank you very much. SC, I never heard you saying that your judgments, both in language and writing, are A+.
No, I didn't say A+. I said I don't have serious comments, criticism.
Yes, I heard you saying from the law bodies, and that question came from the JP.
Yes.
There hasn't been serious criticisms
Yes.
from that end. And that doesn't mean there won't be typos and all of that, because you just told us that English is not your first language.
That's correct.
Thank you.
Thank you, Commissioner Malema. Any further questions, colleagues? All right. Well, this is the end of your interview. Advocate, unless there's anything you want to say to us, you are free to go.
No, thank you. Thank you to all the commissioners for the time. It's valuable time that you give here. And it's all part and parcel that we all, in different views, serve our country. And I hope you find me acceptable, because I still have, coming to the commissioner there with health-wise and so on, I have a lot to give back. Thank you very much.
Thank you.